Hi friends, now we are discussing section 37 of Evidence Act, which is talking about relevancy of statement as to fact of public nature contained in certain acts or notifications. Now there are several different types of facts which are public in nature, but this fact which is public in nature is very specific, which is contained only in acts and notification. Now you know very well what is act. Act means here enactment or any law made by the authorities, something like parliament and state government. Notifications are right from the central government till to the lowest possible village panchayat level. All sorts of elected governments will be passing certain notifications. Even some government officers, departments, and instrumentalities of the government will pass the notifications. If you have proper knowledge about the administrative laws, you will easily understand the word notifications. Now let us see whether any fact which is there in the act or a notification, can it become a relevant fact before the court of law. In order to understand this question or find the answer to this question, we have to line by line read section 37, then only we can understand this. When the court has to form an opinion as to the existence of any fact or not existence of any fact of a public in nature, any such statement of public in nature, if made in a recital contained in any government act of the parliament or in any act of the central government or state government or in a government notification appearing in the official gazette. The condition is very, very important. Any act or notification, if it has appeared in the official gazette of that particular government, either central or state, then only it will become act or notification. Or even any printed paper purporting to be the gazette of the government, such gazette or such published document is sufficient to authenticate any particular bill as an enactment. Once the bill has become enactment, then only it can be called as act. And the notification, you know very well, any notified facts in the form of instructions to the lower level of officers and the subordinate branches of the government, then these notifications have been issued. Such all facts which are maintained in acts and notifications will become relevant facts before the court of law whenever there is a question is arising with regard to existence or not existence of any particular fact. Today we see that several advocates, when they are arguing on any question of law, they are furnishing certain bare acts before the court of law for the kind perusal of the presiding officers. When they present certain act, they say that, my lord, under section so and so, this act clearly says that this particular thing is this and that particular thing is that. If an advocate who is furnishing such a bare act before the court of law, whether he says that this particular act is relevant fact, he will not say that. Why? Because all the acts, all the notifications which are actually law of the land, we can say, which are the time being in force laws, we can say, all such laws which are in force time being, all such laws are relevant facts. You need not to tell that this law, this act is relevant under section 37 of the Evidence Act. You need not to tell it. Why? Because every court is presumed to know that section 37, it is there in the knowledge of the court. That's why whenever advocates are arguing, they will not refer section 37, but whatever section 37 says, they do every day in their day-to-day practice and mainly into their arguments on question of laws. So when this enactment was passed in the 1872, then it was a British India. That's why several words used in section 37 are actually dealing with the British government. That's why I have avoided all such words. I have only taken those words which are necessary to explain this particular section 37 in the context of independent India. Thank you.